Good afternoon, and thank you for joining the Policy and Management Subcommittee today. We're opening it and calling it to order at 5:05 p.m. Can we please stand and do the Pledge of Allegiance? Place your right hand over your heart. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God,
indivisible, with liberty and justice for all.
Thank you. Please be seated. Mr. Fallsgraf, would you like to make some opening comments?
Yes, our chairperson, Dr. DeJesus, is not able to be here due to the callings of his professional work. He sends us all his best. We are joined by Ron Weinkart, who is the district's legal representative, and we'll be talking about the last
to bring this to the board because bullying is touched on in other board policies, but we don't have a specific one for bullying. So this would be something that we would be adding to our board policies.
Okay, so in the work that's been done about staff in the background, remembering that the subcommittee meetings lack a quorum of 3, so there's no business can be done here. The purpose of these meetings is to do some of the groundwork, the background work, take input and that type of thing. So along those lines, staff from the education side of the house, is there anything you want to talk about here now?
No.
Okay.
Keep going. The second board policy that we brought to the education subcommittee is the mobile communication devices. And that one, we needed to decide if we wanted to do one board policy where we have all schools, no phones whatsoever. Or there's 2 options, or policy where some of the children have to keep their phones put away. But when they're not in the classroom, so like during their lunchtime, they can have their phones. And the discussion was that at the middle school, the policy currently is no phones whatsoever. But at the high school, phones are put away during class, but when they are at lunch, they do have their phones that they can use. And the overall consensus was that they wanted to keep the policy the same for the way they are now at the school sites and not have one that dictated to both.
Okay, so that would be the staff recommendation.
Yes, sir.
So, remembering that there's only one of me here, I think that this should be brought not as an informational item or a hearing, but a decision item. I think we've been through the hearing on this and talked about it several times. I think what you can expect is there's going to be a question that you should get a legal opinion on, not here this evening, but so what happens when people are encouraging fights?
With the use
With
of
the phone, and we're
recording.
posting on social media, we're posting people being assaulted. And I'm really interested in what legal would have to say about what culpability the district has in a policy that doesn't protect people's from being beat up on television. And I also would be interested in what responsibility the district has when somebody is seen assaulting and battering someone. And that's not a decision maker, and it's unfortunate that, you know, I understand that the education subcommittee. Representative Dr. Chamberlain is interested in delivering the best education
Mhm.
without being arbitrary, and that, you know. Growing up and being socially proper are part of normal education, because we don't want to send people out in the world that aren't ready to do a job interview. Or practice good policy at work, so. My recommendation to you is to bring it to the board, and then when you do a board agenda with, the board president. Let's get some feedback on that. Is this something you want done before the end of this year?
Dr. Sahaki?
I mean, we can, we have one more board meeting, that would be for June 26th, and then we'll return back in early August.
So we will report out in today's meeting that, those first two items.
Mhm.
Should be on the agenda for discussion and action, at the final board meeting of this fiscal year.
Okay, and I will get the information for Dr. Sahakian as far as the legal ramifications and responsibility of the district for video of fighting and so forth.
Wonderful.
Okay, then we have a new one, which is the alcohol and other drugs. So I compared it because we do have currently that board policy. But this is a new one. As you can see, it was just revised this year in March. So the big differences is if you look under instruction and notification, the very first paragraph, what's in commas, consistent with law, the accompanying administrative regulation and board policy. And it specifically calls out suicide prevention, so it's tying it together to be sure that everybody is aware. The two paragraphs down from, or three paragraphs down from that. It talks about the fact that the district needs to do annual notification to parents at the beginning of the year of the dangers associated with drug use.
And I believe there's a comment here in the policy about fentanyl. Ms.
Yes.
Wright has, you know, made the public aware of fentanyl use and the possible dangers of it as well.
Okay.
We actually added that to our safety plans last year and the site safety plans. That was a new
Yeah.
requirement this year.
Perfect.
And that is referred to on the back page. So if you look at where it says opiates, that's where it talks about fentanyl, that the students in middle school and high school can carry fentanyl test strips. So if they think that someone may have overdosed on something, they have those test strips to see. There's also the enforcement and discipline. The addition on the first paragraph is just the very first 5 words, unless otherwise authorized by law. Everything else there is the same. And then just above program evaluation, that last paragraph, which says that the district may use alternatives to the referral of a student to law enforcement. So those are the changes compared to what we currently have adopted as board policy.
Okay, so when this one comes up for discussion,
Mhm.
I think the introduction of it should be, so is this a first read and a second read action item?
This one would be a first, because this one, I'm just bringing it for the first time.
Right, so bringing this forward, if I'm gonna call out for discussion, if I don't see it coming out of staff. I'd like to see an overview, so anytime that there's as good practice at work, when I'm bringing something forward that has a policy. Steps to it that might be, have to be shown or tracked in a legal action later, I kind of just briefly go over, it's the same slide, it gets tired, but. This is what triggers these, I don't want people thinking in the community that we're just in the background changing board policy, what triggers a board policy change? How do they come forward? Are they sent to you? Is it law? Is it that kind of thing? So kind of just an overview, what this is, what the agency prompts are from above us to regulatory agencies. That legal has a quick look at these, and then it's kind of like. If you're able to call out and just brief bullet points, what's different now, what has changed now?
Okay.
Okay, so that's good. I think there's probably gonna be questions about What does it mean that district staff has the ability to make other arrangements and to notify enforcement? I would need to know what the policy checklist is for that. You know, Tammy Fallsgrass should never be called on the police, no matter what she does, but all those other kids over there, I don't want that. Fair, firm, and consistency of policy and how that varies from, so the suggested language coming from the California School Boards Association is that alternative methodologies might be considered.
Yes, sir.
So that's what came to you in. Okay, so I'm really interested in what that means to the staff that's responsible for making disciplinary policies and,
And also these board policy suggestions, they are, you know, they're like, we can add to them, which you don't usually, but we can take things away, so if this doesn't fit with our view or our, you know.
so the idea that this is the minimum
Your draft.
restrictiveness level and it can be made more restrictive using local control, but not to the point where somebody's civil rights or the
Correct.
law is
Correct,
violated.
yeah,
Gotcha.
or less.
Thank you.
More or less.
Yeah, more or less, and getting legal's input on that, especially when we're making changes, because I think these probably have kind of been vetted, because they're from the.
CSBA.
Thank you for the acronym. But if we make changes, we definitely would want to check with legal, just to make sure that we, you know, are not overstepping or even understepping.
So those were the policies that I was bringing to you. I know that we wanted to discuss also the visitor and volunteer policy. So I'll hand that over to you because I know you'd like to hear from Mr. Weinhardt.
Okay, so where currently is this visitor and volunteer policy? Has it been approved? Is it still coming? Is it, where are we on this?
Well-
From my recollection, this, you know, I don't have a specific date, but I want to say in this academic calendar, we brought the visitor
I
policy
believe so.
to the board in terms of the updates, in terms of CSBA recommended language. Typically, the visitor policies, hard copies are in the front office of each school site campus. But yes, the policy was updated by CSBA and ours wasn't updated for quite some time. But with new language, we brought it to the board several months back.
And it's also included in the volunteer package. When they come to do fingerprints, there's a volunteer package that is given to the parent or, you know, the person that comes in for fingerprinting. And that is included in there also so that they know what the expectations are.
Thank you. Ron, good afternoon.
You have to unmute yourself. You can unmute, Ron.
You're able to do it for him.
Was unmuted earlier. Yeah, he was.
Just press the microphone in the bottom left, Ron. There you go. No. Looking at second host. Can you try one more time, Ron?
There we go. Yeah, I think it was muted at your end because I was trying to unmute, but it wasn't working. So yeah, the policy that I have, I got off your website was adopted in 2005. So I've got the board policy 1250 and the administrative regulation 1250. So if there's a new one, I haven't seen that yet, but be happy to review it.
Okay, Ron, so, and for everyone watching this and whoever will watch it in the future, the purpose of the subcommittees is to do some basic work to see if things are ready for prime time and do some preliminary stuff, but there is, as I mentioned before, not an ability, there's not a quorum here. This carries no weight in terms of formalizing an action. you typically will see the good agencies that have subcommittees or liaison groups. When it comes time for discussion, they may ask what the opinion of the group is. The responsible thing for the people that serve on these subcommittees is there are specific administrative staff directed to help us in discussing issues. Now, you'll remember at the first meeting of this group, we discussed suspension and expulsion policies. And I led Ron through a series of theoreticals as to what happens in terms of having to alter things when it comes to someone who has a declared eligibility and or an IEP meeting, and there's a manifest determination to see if the behavior is what's actually triggering the event that's causing a disciplinary review, and that sometimes that type of stuff isn't popular on the campus, because on one hand, there's the need to protect people's civil rights. On the other hand, there's worries about somebody that is a repeat behavior problem, maybe putting other, and I've actually had people tell me, well, it seems that our classroom is being held hostage. So anybody that wants to see that would simply Google on the district AADUSD, look up subcommittee policy and management, and then you would find expulsion and suspension policies. And I think IT is doing everything they can. Besides posting a library of these things, these meetings are televised and memorialized so people that have questions can understand. Somebody that wants to be on a parent group, a site council, volunteer, or prepare themselves for board candidacy, or enter into a discussion with administrator about some type of thing. People can come in informed and get the groundwork out of the way. What I want to talk about today, Ron, is let's run through a series of theoreticals. Are you ready?
Yes, sure.
So I am on the board. I am the senior board member. I've been here for a really long time, and I have the best interests of the kids at heart. And I'm not sure that everybody that is in the administrative team is making the right decisions. And so therefore, since I was the almost landslide winner by 6 votes in the community, I am going to keep my nose to the ground on the campuses. I'm going to walk in. I'm going to pull the principal aside. I am going to walk into classrooms. I'm going to review what's going on. If I see a kid that I think isn't behaving properly, I'll go back to the office. I'm going to make commentary about people, their performance. I'm going to concern myself with the service they're getting. I'm going to do a cleanliness review of the lunchroom. I'm gonna do whatever I want. I am the board member, Ron. So let's say somebody doesn't like that, Ron. We know what privilege is, and what's the word, immunity. And correct me if I'm wrong, but what that means is a reasonable expectation that if you are, say, a police officer, a judge, a school board member, and if you're operating in what you think is, by measure the average reasonable person, keeping in your lane, then at some point, and somebody says something, then I just say, hey, Ron, I think there's a misunderstanding here. Am I afforded protections when I do the kind of thing I just described to you as a board member, just because of my privilege as a board member?
I would say in most cases, no, because which I think you're referring to is qualified immunity, the concept that the courts have developed over time. And that only applies when it was the rule or the statute or the regulation was not clear, or it hadn't been tested in the past and people weren't aware that they had violated a rule or regulation. But what you're talking about would be a violation of the board bylaws in the 9,000 section. There's a series of bylaws, and I haven't checked yours specifically, but most districts have these bylaws that they receive from CSBA that basically talk about the authority of individual board member versus the board as a whole. And basically, authority rests with the board as a whole, not with individual board members. So an individual board member doesn't have the authority to go onto a campus and tell administrators what to do. That's the superintendent's job. If there's a concern, the individual board members should talk to the superintendent and maybe bring it up at a board meeting, depending on the seriousness of it. And then the board can discuss it with the superintendent. But that superintendent's job is to direct the principal or to direct administrators at the school. So board members shouldn't be getting involved directly with student discipline because, for example, if you get involved with interacting with a student who might be misbehaving at a school, and then later the administration decides to suspend or expel that student, the expulsion could end up with the board ultimately, and then now you've have a conflict of interest. So it's really not the board member's role to get directly involved in student discipline. The other example you gave was, I think, had to do with facilities and whether they were safe or whether they were clean. That's also the responsibility of the administration. So if a board member happens to be on a campus and sees something that doesn't look right or that is unsafe or unclean, it should be reported to the superintendent, and the superintendent can deal with it working with the principal. That's not to say that you couldn't mention it to the principal, but you shouldn't be directing the principal. And the superintendent has the expertise to determine if it's a true safety issue. We have people on the staff who have facilities expertise who can deal with the issue, and then the issue can be reported back to the board as a whole. But individual board members do not have the authority to direct staff, and that's a fairly well-known concept. So if a board member did that and there was a lawsuit that resulted, I don't think a court would apply qualified immunity in most cases. I mean, there could be an unusual situation where the law is unclear and the courts haven't ruled on it before, but in the examples that you gave, the law is pretty clear, and I don't think a court would allow qualified immunity defense in those cases.
So the qualified immunity part, if the district just says, hey, Fallsgraf, you're so far out of your lane here in what you've done, could the district refuse to defend me in an illegal action?
Possibly, yeah.
Okay.
It could, depending on the circumstances. The statute says that if the board member or staff member was acting within the scope of their authority or the scope of their employment, then the district can defend them. So we'd have to look at the circumstances. And then the insurance carrier would also look at the circumstances, and they may say you were acting outside the scope of your employment or outside the scope of your authority, therefore we're not going to provide a defense. So so there's two groups of people that would look at it. You'd have to talk with your insurance carrier and then with legal counsel to review the circumstances. Hopefully it doesn't get to that point. Usually boards usually ask for advice before it gets to that point.
Good. So next, as a board member, do I have a basic obligation to, when I'm around people in my official capacity, tell me what the expectation would be when I'm dealing with people who are employees of the district or volunteers of the district? Do I get a free pass on typical HR mandated behavior just because I'm a board member?
No, you would have to act professionally. If you acted in an unprofessional manner, there could be potential liability. For example, we've had cases in the past in other districts where an employee accused a board member of harassment. We had to investigate it and determine whether there was harassment and then report to the entire board. And then, the board has to decide what action to take. It's, in those circumstances, of course, when you have an elected official, you can't just terminate them or remove them for office. it would have to, have to be some type of recall process. So it's somewhat complicated, but in most cases, what's happened in the past is if there was a report to the entire board that indicated that the board member had harassed an employee or had acted unprofessionally and it was some serious misconduct, usually the board member resigned under those circumstances.
Okay, so let's just agree if we can that whoever is on a campus would realize that it's a professional workplace and that there are employees of the district there, and the employees have the expectation that the district will take reasonable steps to make it a professional workplace. There are human resources rules that go with all of that. And so whether I'm a board member or a representative of the district going onto the campus, I would think it's a reasonable expectation that I would, to the best of my abilities, be aware and mimic the behaviors, best practice behaviors that are typical at that site. Is that a fair statement?
Yes, I mean, board members should always act in a professional manner when interacting with employees. And, if you act in an unprofessional manner, you're creating potential liability. And, board members are not immune from the legal issues or legal restraints on behavior with respect to the workplace. Board members, administrators, employees are all bound by the same laws to have a safe workplace, a healthy workplace where there's no harassment.
So let's shift gears now. This is a tricky question. If I choose as a board member not to call the superintendent, not to notify my board president, and I just decide I'm just going to ad hoc just show up at the district office or the school site office, and I'm just going to go in there, what's the difference between me and any other member of the public? Is it not the same?
Yeah, it's essentially the same legally, in that if there's a problem, you should notify the superintendent, and the superintendent can notify the board president. But any kind of HR problems or facility problems or student discipline problems that you might observe as a board member should be reported to the superintendent, and then the superintendent would handle it in the appropriate manner. And if it's serious, report it back to the board. But a board member should not be directing the principal what to do, should not intervene in an issue. It should be reported to the superintendent. Now, that doesn't mean that the board member couldn't express an opinion and suggest to a principal, for example, that maybe this should be discussed with the superintendent or reported to the superintendent, or I have concerns about the safety of this area of the playground, for example. Maybe we should discuss it with the superintendent. If it's a suggestion, it's probably okay. But if it's a direction, like you will fix this, sidewalk here on, near the playground because I think it's dangerous, and you don't talk to the superintendent about it, or the board, it doesn't, or the board president, then it's a problem. Typically, if a parent complained about something like that, the principal should report it to the superintendent up the chain of command, and then it would be dealt with. And typically, an example like that, superintendent would work with assistant superintendent of business or director of business, whoever's in charge of facilities. They'd go out and take a look at the situation and make a recommendation to the superintendent and to the board as to what to do. If it's a real safety problem, they'd probably recommend fixing it. But it should go through the chain of command. It should go through the proper channels.
So let's dump off that I'm on the school board now. I'm a parent and I have a student there. What I'm trying to differentiate here is, as a board member, I don't think I have any more or less rights than the person who would visit the campus under a similar situation. So whether I'm a board member or not, it strikes me that the behavior expectation will be the same for all visitors.
Yeah, I mean, legally, the board member is in the same position as any parent or member of the community. If a member of community, for example, sees a safety problem on the playground, they aren't gonna, they should advise the principal, and then the principal would deal with it up the chain of command. Board members should do the same thing. But obviously, since a board member uh, would know the superintendent being on the board, the communication would be more likely directly to the superintendent. But legally, the behavior should be the same.
Any visitor.
Any visitor, you see a problem,
So,
report it to the principal, and then let the principal deal with it.
so let's bunch this up at the end and then I'll move into the next area. So what we're saying is if you have board members or people who think by some position they hold gives them some right to walk onto the campus, do whatever they want, act however they want, and just be errant in any way they want, hiding behind some position, that's not appropriate. Any visitor, regardless of position or not position, I think would be expected to look at what the behavioral norms are, what the reporting chain, rules of candor and common courtesy, and especially the kind of modern expectations that require HR directors. So in other words, the board policy about volunteerism, which volunteers are still visitors to the campus, is that correct?
Yes, they would be visitors. They're typically fingerprinted and screened so that they can have contact with children. And we know that they haven't been arrested for any serious offenses that would make them unfit to work with children. So when they're volunteers, there's some extra restrictions. Also, visitors are required to register, and explain their reason on campus. And usually, we don't let third parties, non-parents, just wander around a school campus, particularly in elementary school. If whatever their business is, they state their business. They meet with the principal or whoever. They're meeting with a teacher, and they're usually with a staff member. They don't usually just wander around. And typically, even board members are escorted around. They're not usually just allowed to wander around. I mean, it varies a little bit, but typically, everybody is, should be overseen when they come onto a school campus. They shouldn't just be able to just wander around without any supervision at all.
Is there any concern when somebody's wandering around and making free reign that, things like confidentiality, student records, behaviors, that kind of thing are HIPAA, FERPA, those types of things, those concerns increase when you don't have a good rein on visitors, visitor policy, and the function of everyone and why they're there?
It could happen if you're not supervising people on the campus. For example, the example you give that visitors shouldn't be disclosing confidential student information. For example, if the principal is escorting that person around the campus, it's less likely to happen. And if the person does disclose some information, the principal can advise the person to stop. If you just let people on their own wander around, then you don't know what they're saying to other people. And so that could create a problem. And if it becomes a pattern, if it becomes a serious issue, there could be some potential liability on the part of the school district. So, for example, if you have a parent who's going around talking about other people's children, their discipline issues, their special ed issues, whatever it might be, to whoever will listen, and it's not stopped, and the parent finds out about it, whose child's confidential information is being disclosed, they could go after the school district, sue the school district, and there could be potential liability.
Thank you, Ron. Let's move into the next area. What expectation do employees have when it comes to not being impeded upon by visitors, even up to school board members.
Well, I mean, I think the expectations of employees are that they're able to do their job without interference. They shouldn't be stopped from doing their job. That doesn't mean that they couldn't have a short conversation with somebody, with a visitor. Um, but I mean, that shouldn't be an extended period of time, or they shouldn't be stopped from doing their job, or told how to do their job, unless it's their supervisor. So, yeah, I think the expectation is that they'd be allowed to do their job in the appropriate way. If it becomes a pattern, it could develop into harassment. I mean, if it's constantly happening that a person comes onto the campus and interferes with somebody's ability to do their job, then you're getting to that level that it could be harassment.
Ron, what level of protection do volunteers have? Let's say that I am helping let everybody know on enrollment day at one of the campuses that we have a parent group, and here's our meetings, and we have our table set up, and some parent or visitor comes in and just accosts someone and treats them improperly, and they are a recognized volunteer of the district. Let's say they're wearing spirit wear and everyone knows that they hold a position with one of the support groups, and they're just there helping kids and helping the campus. Do those people have protections from the district if they're unreasonably treated by visitors to the campus?
Yeah, if they make the school district aware of it, if the school district's aware of it, there is potential liability. Their expectation is that they would be treated in a courteous, professional manner. So if somebody's coming onto the campus and swearing at them or using vulgar language or threatening them, and it's reported to the school district, and the school district doesn't take steps to stop it, then there's potential liability.
So they could be recognized as a representative of the district acting professionally, and therefore have right to representation when those rights are violated.
Yeah, depending on the circumstances. I mean, let's say you have a volunteer who's being harassed by another volunteer. So the volunteer who's being harassed, if they don't report it to the district, then there's not much liability because the school district didn't know about it. But once the school district knows about it, once they report it to the school district, then the duty of the school district is to stop it, to put a stop to it. And if the school district doesn't put a stop to it and take reasonable steps to stop it, then there's potential liability. So that volunteer could sue the school district for not stopping the other volunteer from harassing or interfering with what the volunteer was doing. So hypothetically, there could be, some issues.
So I think that concludes my questions. The questions I've asked you, Ron, would you go over the policies, the last update with the superintendent and administrative staff, and make sure that the idea of all that is captured in there and that we don't have any holes in those expectations.
Well, okay, sure. So I could check the policies on liability, defending employees. Okay. The bylaws for board members. Yeah, I'll check all of those.
Thank you very much, Ron. Staff?
So that takes care of everything that we had to discuss today. So we need to decide when our next meeting will be. Is there a desire to have one before the end of the school year? So in 2 weeks at the next, before the next board meeting, or do you want to wait until August for our next one?
I think that's a staff decision. I will report out tonight that we had brief discussions about bringing the bullying, the mobile communication device, and alcohol and other drugs language back for a final board vote, and that we briefly went over some basic housekeeping expectations when it comes to visitor and volunteer policies.
Very good.
So as the need arises, I like it that people are getting ahead of these policy updates
Mhm.
and that people understand that they come to us as through oversight agencies and all those types of things.
Okay, so
Okay.
Dr. Salag, you, August for the next one?
Yes, I mean, I would say that, we have our June meeting, in the books. And reporting out this evening, like Mr. Fallscraft mentioned, so perhaps the next one before August at the start of the school year.
Do you want 14th or 28th?
Whatever's conducive to.
Let's get everybody off the ground and opening the door. So, what I would say is,
Yes.
my priority would be if there's something that's going through the subcommittees, let's say something starts off in the Facilities and Finance Committee, like the power issue. And then my understanding is it came up to the Education Subcommittee. And it goes from, we can't prioritize the generator right now, which is one thing, to the education, side of the house saying, to shut down the school as many times as we have this year and not to have a clear policy makes it really hard for a continuum of education. So you're getting these 2 and 3 and 4 day gaps here and there. And those are two very different things. And then when stuff like that gets fed, it's healthy for everybody to have their opinion professionally on what's important, their priorities. I think at that time, that stuff can flow into here and then it goes out into open discussion. And so everybody feels that their side is being represented and the right thing is being done. There's nothing worse than being a commuter parent that doesn't know when your child is gonna be dropped off, there's childcare issues and all that kind of thing. So I like it to be more predictable when possible than somebody just deciding at the last second, because in this case, it was the power company that was calling you after the power was turned off. So that's just an example how to use these subcommittees and I think that was the idea of it all.
Thank you, sir. So with that, we will adjourn the Policy and Management Subcommittee meeting at 5:48. Thank you, everyone, for participating.
Thank you, Ron.
Thank you. Have a good evening.
You as well.